Hello, good afternoon. My name is Rob Melick, and I'm an estate planning attorney with Melick Law, presenting here the top 13 stories from 13 years of estate planning. I've had the privilege of practicing law for 13 years, and what I'd like to do with today's presentation is just kind of walk through some of those stories. Obviously, names are not being used to protect confidentiality, but I think this should give a little bit of a primer, some happy stories, some not so happy stories, and just some other stories that are just going to hopefully give you guys a little bit more information about estate planning, what an estate plan can do for you, and why an estate plan is important to have. Story number one, the 11th and 9/10 hour. Everyone's heard of doing things at the 11th hour. And again, humans are procrastinators by nature, just kind of the way we're wired, particularly when it comes to estate planning. Again, I'm a first generation lawyer. One of the things that they didn't teach me in law school that I kind of had to learn on my own was just how people view their own mortality and their own existence as it relates to estate planning. I mean, I understood generally that people don't like to think about death and dying, but it is pretty amazing to me after 13 years of practice seeing how frequently people put off estate planning until the very last minute. And this is a call just kind of, a story just kind of explaining that phenomenon. I had received a call from an existing client at 9 a.m. on a Friday. Again, fortunately, I'm very blessed in my practice. I get a lot of my clients from existing clients of mine who are referred to me. And the client indicated that his father was in the emergency room and was finally ready to complete his estate plan. Again, father at this time was in his mid-80s. I said, all right, let's schedule something. We got it on the calendar. About an hour later, I get a call saying the father was given a week to live. Well, that kind of changed the analysis and caused us to expedite it a little bit. We ended up meeting that day. I moved and canceled a few appointments. We ended up meeting that day at 3 p.m., and he passed away a little before 5 p.m. that very night. Again, obviously this is an extreme example, but it did happen. The takeaway is a very straightforward one. Don't put off estate planning. I always tell my clients the best day to create an estate plan was yesterday. The second best day to create one is today. Do not let it go a single day further, whether that's updating a current plan or creating a new one. Do not be in a situation where you pass away and your estate plan is not reflective of your preferences and needs. Story number two, conniving granddaughter or altruistic heir. So again, just to paint a little bit of background on this story, I was very recently out of law school. I was about a year or two out of law school at this time, and I was working with a senior attorney who was in his 70s at that point in time and practicing law for well over 45 years. And he's the one who kind of introduced me into the field of estate planning, so I'm very grateful for his guidance and his mentorship as I found my way into the practice of law. But this story was probably the best story that I had during my time with him. Just a normal day in the office, and a 19-year-old walked into the office with an 82-year-old grandfather. Again, that's kind of unique. I mean, most people come in either on their own or with an adult child. Having a 19-year-old bring her granddaughter in is unique, certainly not alarm-raising in and of itself, but definitely unique. Grandfather, we sat him down in the office. Grandfather said that he wanted to change the trust to leave everything to the granddaughter. We found out the grandfather had 4 children. Again, the current trust had all 4 children receiving a 25% share, as most people in his situation would have done. So he said he wants to change it and leave everything to the granddaughter. So again, both the senior attorney and I were a little suspicious at that point. So what we decided to do was we decided to basically conduct the equivalent of a police interrogation. We met with the two of them separately, simply to confirm that their stories matched up and to kind of just give a credibility assessment as to their respective desires. So we each met with them, we switched, and we met back in the senior attorney's office, and he said to me, "What do you think?" I said, "Well, I'll be honest with you, sir. I believe that they're telling the truth and that this is really what his intention is." And he agreed. He said, "Yeah, that's exactly my take." Again, unusual, but we both believed the grandfather that he was not being coerced or manipulated into giving his money to his granddaughter. Rather, it simply sounded like the granddaughter was the only one who really loved the guy. She was working on she either had or she was working on a nursing degree. She took care of him, and the children didn't. So he thought that he ought to leave everything to his granddaughter. And it was a relatively sizable estate. We're talking well over $1 million here. So we did. We redrafted the documents, and of course, as fate would have it, he ended up passing away less than 10 days later. Again, what ended up happening with this case was it ended up settling about a week or so after he passed away. The 4 children had gotten an attorney, And while we certainly believed in the resolve of the granddaughter said, I just want to be done with this. And they ended up splitting it. Half went to the granddaughter and the other 50% was split between the 4 surviving children. But again, the takeaway here, family meetings are so important. Again, it's something that I emphasize in my practice. Now, of course, there is an attorney-client privilege, and that attorney-client privilege is a very sacred one. And it cannot be waived unless the clients want to waive it. But I do encourage my clients who want to let their children know what's going on. I encourage them to consider waiving the attorney-client privilege as it relates to a family meeting, just to make sure everyone's on the same page. So that's something that I try to impress upon my clients. And in fact, I don't even charge for family meetings. If a family is going through with an estate plan and they want to have a family meeting, I do that on a complimentary basis, just to, again, encourage people to share that information with their children. Story 3, mother knows best, or not. So again, this is just kind of a funny story, a little bit sad, I guess, if you're the people in this situation, but kind of funny from the outside. And again, as we go through the story, I want to emphasize to the people listening here that the child in this story is 15. Okay, so you may hear me say that just to kind of re-emphasize that, because it is kind of crucial to how this story plays out here. So I had a meeting with a husband and wife, and they had one child. They had a 15-year-old child at the time, and they wanted to leave the entire estate to the 15-year-old. Again, very common. Only children typically get 100% of the parent's share, so nothing at all unusual there. The wife asks if any restrictions can be placed upon when the son receives the money. Again, very common. The way the law is set up, the minimum age, of course, is 18. We can't turn money over to a minor in an unfettered manner, so we do have to wait until they're a little bit older. 18 is the minimum. Most of my clients don't want to turn money over to an 18-year-old. Most of us listening have been 18. I'd venture to say most of us are more responsible, mature, pick your positive adjective, now than we were at 18. So it's very common to wait until 21, 25, 30, 35, whatever age you want for unfettered access. So I assume that's where she was going. And I said, sure, absolutely, very common, just let me know the age. And she proceeds to name 3 people, 3 women, and said that she wants it written in the trust that if her son marries any of the 3 women, the son gets nothing and everything goes to the charity. Again, the boy is 15 years old. Keep emphasizing that point. I felt so badly for these poor women who were listed, and I just wondered, what in the world did they do to the son, or maybe more appropriately to the mother, that would make the mother come to this conclusion? But she did. Again, the takeaway here is that estate plans are fully customizable. Okay, I always tell my clients no 2 estate plans are the same. The only limitation is your imagination or overbearingness, as exemplified by this story. Story number 4, stepchildren of the corn. So here's a story. This one's kind of a sad one, a little unfortunate reflection on the state of humanity here. So I met with a husband and wife to set up an estate plan. Husband had 2 daughters from a previous marriage. Again, very common blended families. I mean, when you're living in a world or a country where 45% of marriages end in divorce, it's only natural that as an estate planning attorney, you're going to have a fair amount of blended families. So planning for blended families is very common. So again, this situation did not catch me off guard. Rather, it's pretty common in my practice. The way they had initially set it up was that the daughters were to receive the majority of the estate. There were some provisions for some of the wife's relatives, but the overwhelming majority of the estate was to go to the daughters of the husband that he had from a previous marriage. They had no children together. As fate had it, husband ended up passing away. Well, as fate also had it, unfortunately, the stepdaughters blamed the wife for killing their father by not attending to him properly. Very tragic situation. I heard about this secondhand, but apparently the police were called to the funeral. That's how bad it was. So what ended up happening was the wife revised the trust to eliminate the stepdaughters. Again, the way they had chosen to draft the trust allowed the wife to be able to make changes. Now, clearly, nobody could have contemplated who was going to pass away first. Certainly, nobody could have contemplated that the daughters, or the stepdaughters in this case, would have acted in as unfortunate of a manner as they did. Nevertheless, the clients were aware of and were fully informed as to whether or not we wanted to draft the trust such that the surviving spouse could make changes or could not make changes. And again, in this case, they elected to allow the surviving spouse to make changes, but that's not right for everybody. Some people want to make sure that what they came into the marriage with, or what they acquired during the course of the marriage, goes to their children as opposed to their spouse. So again, it's a matter of preference, but we have to think ahead. We have to think ahead to the possibility of events like this happening and determining whether or not we want to leave the surviving spouse with the ability to make changes. Again, that's a difficult decision to make in real time when we don't have full information. So I encourage my clients in blended family situations to think about the pros and cons, have discussions with their spouses as to how they want their estate plan to be governed, and make sure they make the choice that is good for them. And again, these can be changed up until, of course, somebody passes away. So if two people, husband and wife, leave a meeting and they decide to have their estate plan such that the spouse cannot make changes, and then they change their mind down the road, they certainly can do that, again, while both are alive. So that's really the key thing there. Story number 5, last words to an adult son. So this one's just kind of a funny story. Again, unfortunate given the timing of it, and more from a reflective standpoint to make sure that your loved ones, that you care for them and that you don't take for granted their presence, because again, we never know for any of us, regardless of age, regardless of health, when our last day on earth is going to be. So again, not to sound like a Hallmark greeting card, but cherish those moments and make sure that you're constantly letting your loved ones know how much you love them and care about them. Because this story, albeit in a somewhat funny way, explains how this gentleman may not have had that opportunity. So I met with a couple, and the man who was in a nursing home finally decided to create an estate plan. Again, this is all pre-COVID and everything else, so I went to the nursing home, met with him and his wife, and then they also brought their adult son. The adult son was in the room, and he just basically wanted to be there. No problem. It's pretty common to have adult children in the room discussing estate planning. So again, not that big of a deal. We signed the documents. Husband signed the documents from the hospital bed. I always carry a clipboard to make sure it's easy for people to sign. Well, after the documents were signed, I handed the bill to the wife. I figured that was appropriate. She was not in the hospital bed. Normally I just slide the bill across the table and let people fight over it. But in this case, I handed the bill to the wife. Maybe a millisecond after it left my hand, the adult son snatched the bill out of his mother's hand. And he looks it over, and he claims that the entire process should have only cost $50. He was not happy at the fee that I charged, which was a little bit more than $50 to do this work. The husband's response to the son, because again, it's one of those things where I'm in a hospital room. I'm certainly not going to defend myself to that level. But before I could even say anything, the husband in his bed basically said that the $50 would not even cover the attorney's gas to get there. And again, as fate had it, husband died the next day. So again, just a little story to remind us how precious life is. And again, being able to be in that situation with your father. I mean, the one positive thing was he was there to see his father's last breath. So again, a little bit of a humorous story tied into a much more serious undercurrent there. Story 6, in-laws and outlaws. This is one of my favorite stories. I had a 90-year-old woman come into my office a few years ago, and she decided, you know what? Yeah, it's time to create a will. What I want to say was, well, you probably should have created one 50 years ago, but yeah, that's how it worked. Better late than never, I say. So again, the way that she had her plan set up is she wanted to leave her estate to her adult children and to some of her in-laws. And I asked her what she meant by that, and she said, well, I like 2 of my in-laws, but I don't like the other ones. So how do I make that work? And again, one of the main benefits of trust-based planning, and again, for people who've seen me present or have heard my podcasts or have heard me on radio stations, you hear me talk very frequently about the differences between will and trust-based plans. And again, the main 3 differences the main takeaway difference between a will-based plan and a trust-based plan is that the trust-based plan is guaranteed to avoid probate once the person passes away. In the case of a married couple, it would be the second spouse. In the case of a non-married individual, it would be in the event of his or her passing. So you hear me talk about probate avoidance. Again, 3 main reasons we want to avoid probate. First is cost. Average cost of probate in a state right now in the state of Wisconsin is between about $5,000 to $10,000. That's an average. Some are more, some are less. Second is timing. Average length of probate is about 12 to 18 months. Third benefit is privacy. Wills are public record. They have to be. Not only are the wills public record, but the amount and the character of the assets that pass through the will are also public record. And that's what I encourage this 90-year-old client to think about, that if she created a will-based plan, it would be in the will which in-laws she liked and which in-laws she didn't like. And that was something that she did not want to have. So that was one of the reasons that compelled her to create a trust. Because what I said was, imagine how the next Thanksgiving would go after her passing. The in-laws who she liked would be identified. The in-laws she didn't like would also be identified. So I said, just in the interest of family harmony and everyone getting along, so to speak, probably a good idea to create the trust so that never gets filed with the court. Story 7, walking out. Again, this is a not so happy story of what I do for a living. Again, some of these are funny, some of these are just sad. This one unfortunately falls into the sad category here. So I get a call from a gentleman who said that he'd like to set up a meeting to discuss estate planning with me. Again, very common. He wanted the husband and wife to be there, but he urged me, he basically implored me not to mention the prenuptial agreement, which is tough because prenuptial agreements cannot be superseded by an estate plan. Certainly, two people can revoke or amend a prenuptial agreement if they both agree to that. But again, a lot of people think that an estate plan can circumvent a prenuptial agreement, and it cannot. So I told this gentleman, I said, look, this is an initial consultation. I can avoid it for the initial consultation, but it's going to have to be brought up at some point if you guys decide to proceed. So he says to me, okay, well, I really appreciate if you don't mention it during the first meeting. So I said, fine. So, of course, I'm walking on eggshells the entire meeting. But during the meeting, the husband actually mentioned the prenuptial agreement. And what I can say was I can see why he discouraged me from mentioning the prenuptial agreement, because as soon as he mentioned it, the wife walked out of the meeting and they were divorced shortly thereafter. Okay, I only know that because I received a call from the husband about 3 months later, because I never heard from him. I mean, she literally walked out. He shook my hand, thanked me for my time, and didn't hear from him again. He called me a few months later and said, "Yep, she actually did file for divorce very shortly after that meeting." So again, the key thing here is just make sure you're on the same page as your spouse when it comes to estate planning. It's a cliche, but it takes two to tango. When it comes to estate planning, that's very important. We have to make sure both spouses are on the same page and agree. Now, again, typically, in the case of a non-blended family, we afford the surviving spouse the ability to amend the trust. So if one spouse really disagrees and the other spouse passes away, well, the survivor does have the opportunity to revise it. But again, while both of you are alive, it's very important to make sure you're on the same page with the trust and in the contents of the other documents. All right, story number 8, the fake estate plan. Again, this one kind of caught me off guard. There's really not much of a substantive or didactic purpose to this one. This one's just kind of funny, kind of bizarre. Again, I'm an estate planning attorney. As far as the humor of my job, there really isn't terribly much of it. So we have to pick and choose our moments as best we can here. So this is one here. So I had done an estate plan for this gentleman's brother. The brother had given my name to this gentleman and his wife, and they had called my office to set up an estate plan. So we set up the estate plan. We have the signing, just garden variety situation. Plan to leave everything to their adult children. Again, nothing too out of the ordinary. That is until we were about to wrap up the meeting. And I could tell something was off. The husband and wife were kind of looking at each other at the end of the meeting like I didn't know what was going on. But they finally told me what was going on. And they asked me if I could draft a quote-unquote fake will that would leave everything to the brother who initially referred me to them. And they said they just wanted to kind of play a practical joke on their brother. And I told them, I said, look, I can do that, but we have to make sure that it's done in such a way that there's no possible way that anyone would confuse it. So what I did was I ended up putting, not for publication, not real stuff on the back, and just moved the distribution language to the front of the will, which is not ordinarily where I have it, just so the brother could see it. And I ended up hearing from both the both the brother and my secondary client that they both got a good laugh out of it. So again, estate planning doesn't have to be all serious all the time. Again, it's obviously a very serious matter when it comes to death and dying and planning and everything else. But nevertheless, it's important to have a little fun with it. I don't know about to this level. It's the only time among my 3,800 clients where I've been asked to create a fake estate plan. Nevertheless, I did, and the clients seemed to really enjoy it, and nobody was harmed. Nobody really relied on that, but just got a pretty good laugh out of it. Story number 9, lost and found. So I received a call from a widow who informed me that her husband had passed away, and that husband did all of the banking. And again, this is, not something that happens all the time, and fortunately, it's happening less and less as people get older. What I'm noticing is with an older generation, it tended to be that one spouse, customarily the husband, not always, but customarily the husband would do all of the banking, and again, customarily the wife wouldn't know much about it. And that leaves us with the unfortunate set of circumstances like here. Husband passes away, which is common. Us men tend to predecease our female counterparts, particularly us married men. Not making any commentary there, just stating facts. But again, so when that does happen, it leaves the surviving spouse, again, whether male or female, if they're in a position where they didn't know much about the finances during life, in a really difficult spot. And that's the position that she was in. So she called me and asked what I could do to help. At the time he passed away, she literally had no idea what they owned. To very basic levels. She didn't know what a retirement account was. She didn't know what a deed was. So I really had to explain things to her at a very, very introductory level to make sure everything was done. We cleared up what we thought we could clear up, and thought everything was set away and taken care of. I ended up getting a call from her about 2 or 3 months later or so, give or take. And she told me that she found a bank statement and asked if I could accompany her to the bank. Again, this is all pre-COVID. So I said, sure. I looked at the statement. There's nothing on it to indicate anything, but it was a bank that she didn't have any other accounts with, she wasn't familiar with. So we go to the bank. We sit down with the branch manager, and he tells us that this account was set up by husband. Wife was listed as a beneficiary, and the account had over $125,000 in it. Again, wife was in tears. She had no idea that this account was set up. She had no idea. This was a good portion of their estate. This is a couple who was not incredibly well off. This represented a substantial portion of assets that she had no idea about. So obviously she was very pleased to have found that out. But again, the takeaway here is to communicate with your spouse and to make sure that your loved ones know what assets are available. Again, in a more technological age, I recommend having spreadsheets. Again, a lot of my clients don't want their children to know the exact amounts of assets. That's fine. They don't need to know the exact amount of assets, but they should know at a minimum what type of assets you have. Do you have checking accounts? Do you have savings accounts? Do you have money market accounts? Do you have CDs? Do you have retirement accounts? Do you have life insurance? All of those should be identified. And again, for online banking, passwords, things like that are very important to make sure that your loved ones have. So I definitely encourage my clients. Again, we don't need dollar figures because the dollar figures are going to change anyway as time goes on, but just make sure they have that information at their disposal. I think that's a very important step to take. Birthright is for the birds and other animals. This is one of my, again, it's hard because in some ways I enjoy this story, right? Because I think it shows that this client is doing what she wants to do with her money. But it's also sad because I wonder, what did the kids do to make her come to this conclusion? So I met with a widow who had 2 adult children. Again, I, shame on me, assumed that she would elect to split the proceeds of her estate evenly between the 2 children. I was wrong. That was not her intention. And she wanted everything to go to the Humane Society. And again, I didn't ask this because it's none of my business, but she volunteered the fact that while her children constantly disappoint her, a dog never did. So again, it's her money. She's worked hard for it. She can do whatever she wants with that money. And again, I run into that quite a bit in my practice, that a lot of children incorrectly believe in birthright. And the favorite birthright story I like to tell, and maybe I'm showing my relatively advanced age here by quoting a movie from the 1980s, the movie Rain Man. Tom Cruise, Dustin Hoffman, great movie. Anyway, there's a scene where, and maybe I'm just noticing this because it's what I do for a living, where Tom Cruise goes to the estate planning attorney's office and finds out that his father had left everything to his other son, who's Dustin Hoffman, who's in an institution, and left Tom Cruise with a used car and a set of prize-winning rose bushes. So again, there's certainly nothing that says it has to be divided 50-50. I always tell my clients the only person you cannot exclude from an estate plan is a spouse. Children are not guaranteed anything. So again, I feel sorry for this woman here because obviously her children have let her down, but at the same time, she's certainly empowered enough to be able to make the decision that I'm sure was not an easy decision for her to make, to leave everything to the Humane Society. So good for her for doing that. Drafts and childhood games. Again, for those of you who don't know me, probably the one activity that I have, literally the one activity outside of my kids and my work that I do, is fantasy baseball. I'm a huge baseball fan, huge numbers guy, love statistics, sabermetrics, all that good stuff. And fantasy baseball is just perfect for that. It combines baseball with math, so I'm in heaven with that. And as a result, I do a lot of fantasy baseball drafts and things like that. I'll be honest with you, I never thought that would find a way to get incorporated into my own estate planning, but it did. And probably my favorite story with that is what I call a doll draft. I had a client who had well over 150 dolls, and she wanted her granddaughters to be able to receive these dolls upon death. And she wasn't sure which ones wanted which, so she said, and she maybe put this in her trust, she instructed all the dolls to be placed on her bed, the woman's bed who owned the dolls, and to have all of her granddaughters in a draft type format pick each doll. So as opposed to like an NFL draft where you're selecting players, here the granddaughters were selecting dolls, and that's what she wanted to do. And it was a very specific set of instructions. I've put in requests of games of rock, paper, scissors into documents to determine which child shall receive certain items. So again, when it comes to distribution, you can determine how general or specific you want to be. It's completely up to you. Again, I always tell my clients, the analogy I like to use is I consider myself the equivalent of a waiter. I'm a waiter at a restaurant. You tell me how you want your food, and I'll make sure it gets done that way, within the bounds of the law, of course. But when it comes to preferences, when it comes to the specificity or the generality of the document, again, it's completely left to your own preferences and your own imagination in that regard. Story number 12, the best of intentions. This one's sad. There's just no way to sugarcoat this one. I promise. I mean, we're at number 12. I mentioned at the beginning there's going to be 13 stories. I promise you the last story is an uplifting one, a humorous one. This one, unfortunately, is not. This is the complete opposite. So let me just paint the picture here. A woman came into my office the Monday after Thanksgiving. And again, first thing when the office opened up, she was there and came in the office. I sat down, I met with her. We sit in the meeting. I could tell she shook up, so I figured it had to deal with the death of a parent, and I was right. She said her father enjoyed Thanksgiving dinner with the family and passed away shortly thereafter. In fact, he took his own life. Immediately after the Thanksgiving meal, about an hour or two later, they found him deceased of 2 self-inflicted gunshot wounds. So that's what ended up happening there. Now, before he passed away, he did leave a 10-page handwritten will with very specific distribution instructions to the grandchildren. So the daughter had that document with her. She presented it to me, and I had to tell her that, unfortunately, the will was not going to be enforced. No, this gentleman had written it on some loose-leaf paper, which in and of itself does not make it unenforceable, but the fact that it had no witnesses nor a notary did make it unenforceable. So again, we did have to take the estate to probate. Now, the good news, if there is good news in a story like this, was that, again, the specific distributions were not going to be honored from a legal perspective by the court because he was deemed to have passed away without an estate plan, which means that the state of Wisconsin creates one for him, which in this case left everything to the, I believe it was 5 children, split evenly. Yeah, that's what it was. And so what ended up happening there was the 5 children, fortunately, even though they had no legal obligation to do it, acted upon their moral obligation to follow Dad's wishes and did, in fact, agree to have those assets be split evenly among the grandchildren, even though it was not legally enforceable. So in that sense, they did honor their deceased father's wishes, and that worked out really well. Again, the takeaway is a very straightforward one. Just meet with an estate planning attorney. Make sure it gets done right. I mean, the last thing we want to do is have an estate plan become unenforceable. You know, one thing I've found in my practice is that when it comes to estate planning, this is purely from a client feedback standpoint. When I meet with clients and when we complete their estate plans, the sense of relief that they have is really compelling. It's really a rewarding thing to experience from an estate planning perspective. And almost to a person, they will say to me, this was a lot quicker, a lot less painful, and maybe more importantly for most people, a lot less expensive than they thought it was. It's very important in my experience to make sure that this is done right and that your wishes are accurately captured by an experienced estate planning attorney who can make sure that that does in fact happen. So as far as the final story, again, I promised that I would end on a positive note, and that's what I'm doing here. So this one I call 2020 Vision. I could tell you this, just to kind of set up the background for the story a little bit. This is one of my first jobs out of law school, actually the first job I had out of law school. And I had met with a person at the firm. It was a larger firm. It was a younger paralegal who was about my age, mid-20s at the time, who said to me, she said, can you help me with my grandmother's estate planning needs? I said, sure, I'd be happy to help. She's a paralegal at the firm. Paralegal says to me, well, my grandmother is in a nursing home. Can you still help her? And again, this is all pre-COVID and everything else. I said, sure. I said, the only issue is she has to have capacity, right? And that goes for any estate planning document, that the person who's trying to get the estate planning documents created needs to have capacity. They need to be able to understand the documents that they're signing. They need to understand and make conscious choices as to whom they're having serve in various roles. I said, now she's in a nursing home. Maybe she has it, maybe she doesn't. I'll have to make that determination. And the granddaughter reassured me that, yeah, grandma's fine. She's doing well mentally. She's just a little frail and physically not in the best of shape. I said, okay, well, let's see how it goes. So we end up meeting at the nursing home that weekend. I come into the room. I keep my space. The granddaughter's talking to the grandmother, and paralegal granddaughter kind of pushes me, motions me forward. And I introduce myself. I say, ma'am, my name is Rob. I'm an estate planning attorney. I work with your granddaughter here. I said, I understand you're interested in some estate planning. And she says, and she doesn't really say anything at first. She just kind of looks up at me, kind of glassy-eyed, and she goes, are you my doctor? And I'm thinking, this isn't good. I said, no, ma'am, I'm not your doctor. I'm an estate planning attorney. I work with your granddaughter here, and we want to make sure that you have a plan set up. My understanding was that you had talked to your granddaughter. You want to have some documents set up to determine where assets go, who's going to be in charge of your estate, things like that. She looks up at me again, and she goes, I didn't think you were my doctor. He's a lot more handsome than you. So I remember pausing thinking, wow, her vision's great, outstanding vision, clearly competent and clearly has the capacity to execute these estate planning documents there. So again, it's a good thing to have a little bit of a sense of humor when it comes to estate planning, and I certainly did there, even though she kind of insulted me, but I'm sure the doctor was much better looking than I was anyway. So again, I'd like to thank you for listening to this Lunch and Learn here. There are future Lunch and Learns that are available through Client First. They do them every month. And again, thank you for the opportunity. And if there's any follow-up questions, my phone number is 262-347-3444. Again, 262-347-3444. I'd like to thank Client First Tax and Wealth Management for the opportunity to present at their Lunch and Learns. And I look forward to seeing you guys at future events. Have a great day.